Hello, everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So, we hope that you all had a very nice, enjoyable, safe, and green Diwali. On this note, let's see what are the articles that we will be discussing today. So we have two articles. The first is from the Hindu, which is titled as a recipe to tear down trade unions. So basically, this is regarding the impact that the recent labor laws are going to have on the very presence, or in a way, the very life of trade unions, and what is the importance of trade unions, a brief history of it, and how it will not be a good, it is not a good sign to have these labor laws if we talk about the trade unions at all. And secondly, this is from the Indian Express, which is titled as "Only Willing Consent." This basically specifies about the various state governments that are probably for some reason are coming together and are contenting to bring out some legislations against what they recognize as love jihad. So, what basically we understand by love jihad? Does it even have any sense or not? And what are the constitutional implications of doing this? And finally, we have the news and flash column, wherein we'll be discussing the small and crisp news points that are more important for our prelims exam. So, if you're also preparing for the Judicial Services exam, you can definitely have a look at the Law Shikho course that we have for you. So, we have a very good course for judiciary preparation, which we call as the Lord of the Courses. The link to this course is there in the description box below. You can definitely check it out. And from the landing page of this course, you can also download free study material for yourself. Then we are dwelling into various other courses like CLAT, All India Bar Exam. Then we have Judgment Writing course, SEBI, etc. You can have a look at them too. So this is the multiple choice question for the day. RCEP, recently seen in news, stands for first, Reciprocal Cooperation in East Asian Partners. Second, Regional Comprehensive Economic Partnership. Third, Rural Committee for Economic Plan. Or fourth, Reverse Clean Energy Plan. So if you know the answer, you can put it down in the comment section below. This is the descriptive question for the day. Discuss the role played by trade unions in representing the workers and fighting for their rights. How have the new labor laws affected them? So you have to take two parts in this answer, wherein first you have to discuss as to what is the important role that the trade unions play, and secondly, what would be the impact, now be it the adverse or a positive one, through the new labor laws that have recently come into force. With this, let's discuss the first article for the day, which talks about the trade unions in India. So, as we have already said, that the new labor laws, as we know that recently we have had four new codifications of the four new labor laws, which have actually subsumed a lot of other pre-existing labor laws. So, they have been alleged to be an attack on workers' ability to safeguard their rights by means of trade unions. So, in a way, where at the other side, these new labor laws try to promise or they say that they would be a better claim for the rights of the workers, on the other side, and that too on the contrary side, it has actually hampered the ability of the workers to safeguard their rights through collective means. That was through trade unions. So the government has actually excluded trade unions from pre-legislative consultations. Now, as we know that in India, many a times when the legislations are formed, so the stakeholders are brought into discussion, and even before the proper or the complete legislation is formulated or given a concrete form, the stakeholders are given a chance to put forward their concerns, and keeping these concerns in mind only, the complete legislation is formulated in the concrete sense. Just like recently we had the legislation of the environmental impact assessment, wherein it was said that the time period which was given to the stakeholders to put forward their concerns was not very sufficient, and that is why it should have been a greater time period so that the people could have easily participated into the discussion of the legislation. Similarly, on this ground, the government has actually excluded the trade unions from the pre-legislative consultations, which actually shows that government is doing something which is not really supportive or which is not really good for the impact for the trade unions. And this is not a good sign when we talk about the collective rights that the workers hold in any kind of employment. So let's understand a very small and brief history of the trade unions. So basically, the very concept or the complete formalization of the trade unions, it came in the 19th century when it was first introduced. So these were the self-managed organizations of workers. So earlier, they just on their own selves they came together and they managed their union on their own, and they were actually the means for providing a collective voice against employers' exploitation, because since time immemorial, this has been a much debated concept, wherein, like if you talk about the Karl Marx as well, so he was totally into socialism, and his theory was like the entire tussle or the entire fight or friction between the bourgeois and the proletariats, which was the elite class employers and the much oppressed workers. And in the same sense, there has always been a time where the employers, the people who actually employ the workers, they tend to harass and they try to exploit the workers in order to gain maximum benefit. And that is why the trade unions were very crucial, and they still till date very crucial, for providing a collective voice to all the workers against the exploitation that is done by the employers, and also against the unfair and often illegal practices that are many a times taken up in various kinds of employments. Like for example, they might not be given various kinds of their rights, the holidays, the rightful or the paid leaves for that matter, health benefits, medical benefits, any of that sort. So this actually resulted in better wages for the workers, fairer employment conditions, and safe and secure workplaces. So now we can easily understand as to the role that has been played by trade unions is very crucial, as in a way it is something like for example, you take a woman who is a victim of take for example domestic violence. So there are a lot of NGOs that outrightly support such women, and that is why they play a very important role in providing the rights of such women to them. In similar situation, or in a similar analogy, the trade unions also play a very important role in providing the rights and claims of these workers. So here are some examples of the very prominent trade unions that are that till date they are available in India. Like we have on this Mazdoor Sabha, Indian Federation of Free Trade Unions, All India Trade Union Congress, Bharatiya Mazdoor Sangh, etc. So these are all very prominent trade unions that actually represent thousands of workers through them. So then, as the time went forward in 1926, the Trade Union Act, which is TUA, or the Trade Union Act, or the TUA, was adopted. So basically, this Trade Union Act provided a mechanism for, firstly, registration of the trade unions. Now, as you know, that anything is, if it is registered, many of the times it is subject, or it is given more freedom to function, and it is given better rights, a better space and scope to function. And that is why the Trade Union Act, the provision under this Trade Union Act for the registration of trade unions was very important. And through these, the trade unions got registered, and thus they became the formal and, in a way, an official voice of the workers that were under a particular trade union. And also, the Trade Union Act provided for a framework for governing their functioning, because obviously many a times it is not something that there can be no corruption or there can be no malpractice within a trade union itself. Many a times even the leaders of the trade union might want to exploit the workers that are a part of the or the members of the that particular trade union. And that is why the Trade Union Act gave a complete formal setup and a complete formal framework according to which a particular trade union has to function. And that is how it ensured that even better rights are provided to the workers of any trade union, or the members of any trade union. Then it provided for immunity against law of criminal conspiracy for members and the elected officers of a trade union. Now this is a very unique feature which is which makes, or which actually gives the trade unions a special status when it comes to the employers or the workers association, wherein the very the offense of criminal conspiracy, which is under section 120B of the Indian Penal Code, the trade union members, like the members and also the elected officers of that particular trade union, are immune from this law of criminal conspiracy. Because, like for example, there are 100 workers that are part of ABC trade union. Now they're not very happy and satisfied with the way their employer is treating them, or maybe the wages are not up to the mark, or be it any reason, and they have decided to rightfully sit for a strike. Now strike is something, it is a right which is not illegal. So this is a very tricky question, because strike per se is not someone's legal right that you can claim. But yes, if you are protesting peacefully, then it turns out to be not an illegal act. So that is a different discussion altogether. But yes, for example, these 100 people, and one of them is the officer or the leader of the trade union, and they all decide that we will be sitting on a strike on so and so date against these exploitative acts of this particular employer. Now, they are definitely coming into consonance and acting in a particular coherence. In a normal situation, this might be taken as a criminal conspiracy by, or if we see it from the side of the employer. But the very aspect or the very presence of them being a part of a trade union makes them immune from this law of criminal conspiracy, and that is why they can function and demand their rights in a very easy and in a very active manner. Legal recognition was given to actions based on collective decisions. So if some collective decision has been taken by the trade unions, the members of the trade unions, then legal recognition and the legal outlook to that particular decision has would be given. And deregistration was limited to the internal functionaries of a union. So basically, deregistration is just the opposite of the registration of the trade union. So a particular trade union could be taken off, or the registration of that particular trade union could be taken away only on the grounds of some internal functionaries or some internal tussle if it's going on in the trade union. And that is why it was very in very less probability that a particular trade union would be deregistered. And then in the year 1999, the Second National Labour Commission was set up, which submitted its report in 2002 and had limited the trade union representation. So it is right from the time of 1999, wherein the very scope of trade union is trying, the governments are trying to put them to decrease the scope of trade unions, because see, there are a lot of reasons that can be attached to this contention, because many a times, obviously, the employers are in a better capacity to strike a deal with the government. So if the government maybe there might be some kinds of political benefits that the employer is able to give to that government, maybe some kinds of economical beneficial benefits, wherein the employer would is in a better position to bring the government or the contentions of the government into his favor. And that is why here the trade union is something that actually bars the very growth of the employer in a if at all it is at the cost of the employees. So that is why the scope of the trade union has been tried to be minimized with time, and that is why recommendations. But even till date, you can see till this time in 1999, the trade unions were very strong, and since they were made a very active part of the pre-consultation procedures, the decision-making procedure in these laws, so these recommendations were outrightly rejected by the trade unions across the country, and that is why the very scope of trade unions could not be really limited. But with these four labor codes that have recently come into action, the very scope of trade unions has come to big question mark. So let's see that what are the issues with the new labor codes. So firstly, a trade union can be deregistered for contravention of the provisions of the code that which is mentioned under the Industrial Relations Code 2020. Now, as we just saw, in the previous situation under the Trade Union Act, the deregistration was it was in a very rare chance that a trade union could be deregistered. But on the contrary, after these new codes that we have and after the Industrial Relations Code 2020, the deregistration can be done in a very vague manner as well. And it is just mentioned that it can be done if the trade union functions in the contraventions of the provisions of the code. Now, about which provisions of this particular code you're talking about has not been made clear. So in a way, it again would depend on the whims and fancies of the employers and the other stakeholders in this regard, that it would be very easier now to deregister a particular trade union. So basically, this actually shifts the balance in favor of the employers, and it violates the principle of equality and natural justice, obviously, because trade unions were the ones that actually promised equal representation and natural justice to a huge number of workers. But now, since it would be so easy to get these trade unions deregistered, so that definitely it will be a question upon the principles of natural justice and equality as well. So the other implications of deregistration are the trade union can no longer represent its members before dispute resolution machinery and courts, because obviously if the trade union is not registered anymore, it will have no identity at all. And that is why it will not at all be capable to represent its members or the workers to any kind of resolution machinery or even courts. Then any collective decision which was taken by the members or the elected officers can be treated as illegal. Like, for example, on this particular date, a decision to peacefully strike was taken by the trade union members, but now on the very next day the trade union stands dissolved and it is deregistered. So definitely the decision that was taken beforehand also stands dissolved. So the loss of immunity from action of criminal conspiracy, as we just discussed, that here they were given the right, they were actually given immunity from the criminal conspiracy law, but now definitely they will not be able to enjoy this as well. And the workers might be forced to create extra legal formations. Now, since trade unions are no more available for them, like if they are deregistered, they would no more be available for fighting for their cause. So they would be compelled to become a part of extra legal formations. Like extra legal, that is something that the law does not really permit, but still they are formed outside the purview of the law. Like for example, the struggle committees at the fronts of the workers, that would also push the employment dispute resolution out and also criminalize the working class dissent. So there are huge implications that are attached with the recent labor laws, and that is why it is very necessary that we look into every corner and every aspect of the stakeholders, and only then we decide to implement these laws in full and fledged manner. With this, let's move towards the second article for the day, which talks about the consent and marriage in India. So, the many state governments have announced their intentions of enacting law against love jihad. Now, the concept of love jihad has no legal or constitutional basis. Now, basically, uh, if we talk about a basic general understanding, if a person who's plural, who is very secular, so the concept of love jihad is something nothing more than a political issue. So basically, they think that whenever persons or the people belonging to two different religions, and now here the mostly hyped or the hugely hyped religions, the only two religions are Islam and Hinduism. So basically, according to the concept of the so-called concept of love jihad, they believe that one person who belongs to a particular religion actually compels the other person to convert into his own religion and then marry him. This, and by this they actually try to change the demography, and they also try to make or increase the number of people in that particular religion, which, to basic understanding, it is something really very difficult to understand, because this absolutely makes no sense. Because if somebody is adult and is deciding to change or convert into any religion, or even to follow no religion at all, it is his own conscience, is his own or his or her own decision, and that is why it does not really have any kind of constitutional or legal basis. Now let's understand the jurisprudence behind this concept. So the Supreme Court, in the case, as we know, the very, very famous case of Hindu law as well, and conversion specifically, with the Lily Thomas versus Union of India and Sarla Mudgil versus Union of India. So it was said that second marriage of a Hindu husband after conversion to Islam is not valid under Section 494 of the Indian Penal Code. Now, many a times, specifically in the times from 1990s to 2000, it was very prominently seen that, for example, there is a Hindu man who is married to a Hindu woman according to the Hindu rites and rituals. But now he falls in love with another woman and wants to marry her. But obviously, since bigamy is not allowed under Hindu law, so it would be a criminal act if he does so, just in the same situation. So what he used to do was, he used to first convert himself into Islam. And since Islam allows polygamy, and that too, that is like 4 marriages are allowed for a man. So then after converting to Islam, he would marry the other woman, and then he would like live a simple life wherein he had 2 wives. And since now he is professing Islam, it would not be a criminal act. But this was seen so rigorously that many a times people, not just not merely for the sake of really believing into a particular religion, but just to exploit the very freedoms or the very rights given under Islam or any other religion for that matter, they were converting from one religion to another. So, if I'm not wrong, you can definitely look into one example wherein where the very famous actor Dharmendra, he was already married. So then he and the very famous actress Hema Malini, they fell in love, and then Dharmendra also had converted to Islam and then married Hema Malini, and then probably he divorced his previous wife and then he got back to Hinduism, stuff like that. So it was very prominent those days, and even today many people try to do this. So in this case, it was said that if somebody is doing just for this purpose, then it would not be considered to be a legal act, and it would not be valid under Section 494 of the Indian Penal Code. So it said that Hindu marriage cannot be terminated by one spouse converting to another religion. So if at all, if even if the husband converts to another religion or the wife converts to another religion, still the marriage would stand very much valid, and it would not be terminated by just doing of this act. So the other related constitutional provisions, as we know, are Article 21, which actually is right to life, which gives the right to marry a person of one's own choice, and Article 25, which gives the freedom not to follow any religion or to follow any religion. So basically, the only important thing that we need to discuss in this article is that when we are talking about the fundamental rights, or maybe any rights for that matter, but specifically since here two of the most important fundamental rights are into question, so it says that one right cannot invalidate the other, which means that if I would want to exercise Article 21 as my fundamental right, it does not mean that I would have to compromise on my another fundamental right which is available under Article 25, and also vice versa. For example, let's understand this with an analogy. If at all I would like to marry any person who belongs to some another religion, that is so in that sense I am exercising my right to marry any person of my own choice under Article 21. But then again, I also want to follow my own religion which I want to follow, and I don't even want to compel the other person to follow the religion whichever he wishes to. And that is why the exercise of one article or one fundamental right is not on the not in order to compromise the other, and both can go hand in hand, which means that I can marry a person of my own choice, plus I can also profess the religion of my own choice. So both can go hand in hand. So this is the basic contention which has been given under this article, that we don't really have to make a choice, and that is why the state governments need to analyze and realize the fact that love jihad altogether is a very political and separate issue. And that is why if you would try to bring legislations into the solemnization of marriage of two adults, then that is something not really very acceptable in a democratic setup like India, that when we have in the secular state like of ours. With this, let's discuss the news in flash for the day. First, draft rules on Code on Social Security. So these have been released by the Ministry of Labour and Employment for public comment. The rules provide for Aadhaar-based registration on the portal of central government rules regarding gratuity on fixed-term employment and procedure for self-assessment and payment of cess. So these draft rules are linked to the EPFO, which is the Employees Provident Fund Organization, ESIC, which is the Employees State Insurance Corporation, National Social Security Board for Unorganized Workers, and gig workers and platform workers as well. And we had been discussing about the gig workers and platform workers as well. So if you remember, gig workers and platform workers were those like the delivery men, the delivery boys and girls, Ola, Uber, and stuff like that. Then secondly, RCEP takes off. So now we know the RCEP is the Regional Comprehensive Economic Partnership. So the 15-member partnership, which is led by China, has actually now started formally. And India is not a member. Please remember, India is not a member of RCEP, though it had to join RCEP, but due to some economic restraints and some reasons, we could not join RCEP. But it says that India would have to write and expressing intention to join the organization later on, because the RCEP members say that we are very much ready to welcome India even at the later stage to restart the negotiation for membership. So basically, this is the in current scenario, it is world's largest basically free trade agreement which is going on amongst various nations. So there are 15 members of this. 10 like one is the ASEAN countries, and then other 5 these are the 10 ASEAN countries, and then we have China, Japan, South Korea, and Australia amongst the other 5 members. So with this, we're done for the day. We hope it was a good session for you. Stay tuned with Law Seekho for such more sessions to come. Thank you so much.